exciting, I'm sure.
Exciting to acquire in your hometown.
Yeah.
Good afternoon, Your Honors.
Hello.
May it please the Court, my name is Sean Aiello of the Williamson County Bar, here on behalf of the appellant Nicole Neuman. Before I begin, I'm reserving 5 minutes for rebuttal.
5 minutes, all right.
On appeal, Ms. Neuman asked this Court to, 1, reverse the trial court's final order that declined to accept the confirmation and registration of the April 29, 2022 Utah court order, and also to reverse the trial court's final order that ruled the same Utah order null and void. Now, we're also asking the court remand this matter to determine the appropriateness of awarding Ms. Neuman her attorney's fees, both associated with the enforcement of this Utah order as well as for the successful defense of the criminal contempt action that was brought against her under these same proceedings. Your Honors, the primary claim for relief on appeal essentially boils down to one significant question. And that question is, when did the Williamson County Chancery Court assume jurisdiction over the parties and the minor children, taking that over from Utah? The appellant respectfully asserts that the trial court erred in repeatedly ruling that jurisdiction transferred upon the appellant filing her petition to modify on September 15, 2020. First, under the UCC JEA and TCA 36-6-217, jurisdiction remains with the state making the initial child custody determination until such time as either that state or this state makes a determination that neither the party nor the child reside in that state, or neither one party and the child reside in that state, and there is no substantial evidence remaining in that initiating state to retain jurisdiction. Second, the first court that made this determination that Tennessee did in fact have jurisdiction was the 5th Judicial District for Utah in its April 29, 2022 order relinquishing jurisdiction. And until such time as that order was entered, neither Utah nor Tennessee had entered an order confirming that either state retained jurisdiction over the parties. This case initiated in June of 2020 with the first filing of a request for registration of enforcement filed by the appellant seeking to register and enforce the original divorce decree from 2017 out of Utah, as well as a self-titled written relocation agreement that was not reduced to an order but was submitted as if it was one, first to the Utah court and then as an attempt to register in 2020. Neither party contested at that time the initial registration, the enforcement, or registration of either one of those documents, but ultimately it did become an issue throughout these quite lengthy proceedings as to whether the supplemental divorce decree from 2017 or this written relocation agreement contained the binding parental guidelines for these parties. And ultimately, in March of 2022, Ms. Neuman, the appellant, filed in the course of these proceedings a motion or a petition in Utah to determine and to enforce this written relocation agreement to reduce that to an order form to be used in the Tennessee court for enforcement purposes. After she did that, there was a request for a UCC JEA conference between Utah and Tennessee, which occurred in March 28th of 2022. And a result of that UCC JEA conference between these two jurisdictions, the trial court here entered an order stating that it had conducted such a conference and that an order would be forthcoming from Utah relinquishing jurisdiction. Ultimately, that order was entered by Utah on April 29th, 2022, after which the appellant, Ms. Neuman, again filed to register that particular order with Tennessee for enforcement. Between May of 2022 and the ultimate trial on this case in May of 2023, the appellee, Mr. Phillips, did not contest or otherwise oppose the registration of the April 29th, 2022 Utah order, which under the particular analysis of registration, we would state that under 36-6-229A, Mr. Phillips was served with an adequate notice of his right to contest and the impact of what failing to contest would actually impose on these particular proceedings. And as made clear under subsection E and F, failure to object to this registration results in confirmation as a matter of law that this particular order should be registered and be enforced. The first time that the Tennessee court ruled that the April 29th order from Utah was not a valid order was as a result of the final hearing in May of 23. It incorrectly determined that Utah could not have issued its order relinquishing jurisdiction and reducing the supplemental or the written relocation agreement to order form because it had no jurisdiction. It determined that order to now be null and void. However, no hearing ever took place to contest the legitimacy of that April 29th order, and the appellee did not otherwise contest it until that day of trial. There was no request for a specific hearing that would typically be required under those particular
Counsel, does
set
it
of facts.
matter that 36.6.229 D1 specifically anticipates as part of a hearing that one of the bases of challenge would be a lack of jurisdiction? And does that matter in terms of the analysis with the court sort of sua sponte or after the 20-day time period raising the jurisdictional issue?
I think it's important that it's laid out as one of those particular issues that should be raised in the opposition to the registration of that order. And I think the specific timing requirements that this opposition be raised within 20 days is not just a guideline, but a very useful tool for the parties to understand which orders they are litigating with and what effective jurisdiction has on which parental order is in effect. And so when we have a request for registration that is essentially laid dormant for a year without any request or opposition to the enforcement and registration of the same, to then allow the court to sua sponte make what really should have been an argument of the opposition party to say that there was no jurisdiction of that order really shifts the responsibility unjustly to the court as opposed to the appellee who should have raised that as an issue in response to the initial request. It's interesting when examining what the differences are between the written relocation agreement that was signed by the parties, notarized, and drafted by the appellee's attorney and filed in Utah. It appeared from that document that the parties intended to be bound by it. But when faced with the differences between some of the important transportation requirements and inclusion that Williamson County would retain jurisdiction and would be the place of schooling for the minor child, father then decided that he didn't want that written relocation agreement to be enforced. And so when we're looking at what the effect of this failure to object and the court's determination that not only that the underlying Utah order was null and void, but that it would not consider the provisions of the written relocation agreement, even having assumed jurisdiction, we're faced with really just a complete discounting of this document that was intended to be a modification of the supplemental divorce decree from 2017.
If a Tennessee trial court is essentially looking at protecting its jurisdiction in a case, it's not essentially the trial court here could have made a finding that everybody's present in Tennessee, no one's present in Utah, and that would have been a basis for establishing, essentially taking jurisdiction away from the Utah courts, putting it in the Tennessee courts. The trial court in Tennessee could have acted on the trial judge could have made that finding here.
Exactly. That's that 36.6.217, that requirement that a court would make that finding. It didn't have to be this court. It could have also been Utah if they determined that provision of the UCCJEA, which is factually similar in both states, applies. But in this case, we do not have an order that predates the April 29, 2022 order from Utah that states that it's relinquishing jurisdiction in favor of Tennessee. Was
that necessary though? Was that order necessary? I think that's what we're talking about, is whether the fact that the child was here, the parties were here, had been here for more than 6 months. Couldn't the Tennessee court simply assume jurisdiction in this case?
Yes, Your Honor. It could have, if it had done so in any sort of written order form, making that determination of those specific requirements of jurisdiction. In this case, though, the court conducted the UCCJEA conference and deferred to the Utah court to enter its own order relinquishing jurisdiction. Whether that was a requirement, I don't believe that that's necessary, but here the court, rather than entering its own order, relied upon Utah to issue its own order relinquishing jurisdiction at that time.
But then he determined that Tennessee had jurisdiction prior to that time.
There's no order or document that says that it did. There were proceedings that occurred prior to this UCCJA conference, but those primarily related to enforcement mechanisms, contempt on the existing parenting plans, and some substantial back and forth on recusal motions that really never got to the merits of jurisdiction on the underlying case for modification purposes. Thank you.
Thank you. Mr. Phillips, you understand you're representing yourself?
Yes, Your Honor, I do.
Oh, that's fine. You have every right to, and you have 15 minutes to present your side of this.
Very well. Thank you, Your Honors. My name is Paul Phillips, and as you all know, I am representing myself pro se. This is my first time appearing before this court. I did have experience representing myself as pro se and was a person of record as pro se at trial. I did not bring counsel with me with more experience today. However, I am ready to speak with you guys. The ostensible complexities presented throughout this case attempt to make it difficult to discern clarity of facts. At its core, the argument from the appellant is pointed towards the Utah order dated April 29th, 2022, which purportedly reduces the written agreement for relocation to an order, while also highlighting an alleged failure to contest the validity of the registration referencing Tennessee Code 366229. The trial court assumed jurisdiction applicable with Tennessee Code 366218, as Tennessee was the home state commencing the child custody proceedings to which the appellant petitioned on September 15th, 2020. Notwithstanding, prior to this action, consent in record was provided to the Utah court that Tennessee would assume continuing exclusive jurisdiction, and subsequently, the trial court cemented exclusive continuing jurisdiction through its March 4th order. During the hearing in March, it was found that neither parent nor the child was living in the state of Utah and had not been living in the state of Utah commencing the proceedings. It was determined that the appellant, in fact, had moved to Michigan and that I was living in Tennessee. This unambiguously makes clear that no party nor child was living in the state of Utah and that Utah did not have jurisdiction to enter any orders on April 29th, 2022. The only orders that are valid is the Utah order entered June 3rd, 2020, which is the initial child custody determination, supplemental decree of divorce, and any subsequent orders that were entered through the trial court in Tennessee. Your Honors, I don't have much to say, pending any questions that you may have of me about the facts, trial, or testimony in this case. I would like to highlight, in my opinion, the history of forum shopping and protracting litigation, which has caused significant and exhaustive efforts to identify the facts of this case. I'm more than happy to answer any questions.
Don't see any. No questions.
Thank you.
Well, thank you, sir. Mr. Aiello.
Your Honor, some reference was made to the March 4th, 2022 order that was issued by the Williamson County Chancery Court prior to the UCCJEA conference held on March 28th. Importantly, that order is, again, an enforcement order of certain provisions of the registered divorce decree and did not make any modifications to the initial custody determination. It also makes no determinations as to mother's residency. It does state that father lives in Trousdale, as does a minor child having relocated from Williamson County, Tennessee, but it does not contain the requisite findings of 36-6-217 that would assert jurisdiction for modification purposes, which is an important distinction versus an order that assumed jurisdiction, modified the parenting plan, or changed custody in some degree, which in this case would be an affirmation of assumption of jurisdiction that would satisfy the UCC JEA. Additionally, within the court's memorandum and order, the final order, it asserts several times, at least 3 times, that jurisdiction transferred not as a result of this March order, but as a result of the appellant filing a petition to modify on September 15th, 2022, 2 years before it has a UCC JEA conference. That assertion simply is not supported in law or by the facts of this case that jurisdiction transfers at that time. And as is well-established principle, parties cannot convey jurisdiction without the court affirmatively finding that it in fact does. It also states in the memorandum and order multiple times that it ruled the April 29, 2022 Utah order null and void multiple times before the final hearing. A review of the orders that predate the final hearing, however, show no such ruling had occurred. There were attempts and requests by the appellant for the court to issue a determination of which document governed for the purposes of modification, which is whether it's the divorce decree or this written relocation agreement, and at each turn the court declined to make any such ruling prior to the final hearing. And so, again, looking back to the requirements of registration and enforcement, the appellee has essentially waived any opposition to it by not availing himself of the rights he was duly advised of at that particular time. Both at the trial court level and on appeal, Ms. Neuman does request an award of attorney's fees under 36-5-103C for the enforcement of a parenting provision, which is essentially the written relocation agreement encapsulated in the Utah order, should this court determine that enforcement and registration was in fact proper. She's also seeking an award of attorney's fees for successfully defending against 10 counts of criminal contempt brought by father that were heard on the same day and as part of the same action against her in the Chancery Court. Ultimately, Your Honors, this comes down to a question of assumption of jurisdiction, when did it occur, and at what point the trial court of Tennessee became the presiding court to make modifications. It's the appellant's position that occurred after entry of the April 29th, 2022 order that both the Tennessee court contemplated, requested, and referenced within its own orders after a UCC JEA conference. So accordingly, the appellant respectfully requests the court reverse the trial court's final order in this matter and determine that the appellant properly registered the April 2022 Utah order and order enforcement of the same, as well as a remand back to the 21st Judicial District Court to determine the appropriateness of an award of attorney's fees either on appeal and as a result of the trial court as a prevailing party of registration, as well as prevailing party in defense of a criminal contempt action. Thank you.
Thank you. Thank you both. Would you please adjourn court for the afternoon?